May it please the Board, Ellison Edgeler appearing for the appellant, Mr. Warren from Pitcairn.
Apologies for starting slightly late, yes.
I appear as Attorney General for the respondent, Crown, together with Mr. Raftery, prosecutor, and Ms. Kelly.
Right.
Between ourselves, it's proposed that as Attorney General, I'll address the constitutional and systemic issues. Mr. Raftery, if required, will address any issues arising from the trial itself.
Right. Good. Again, apologies that we're starting slightly late. I think what we're going to do, unless it's inconvenient to you, is actually rise at 3 today and sit again at 10 tomorrow. Does that create any problem? Right, now have we worked out what the programme is? You're going to deal with the whole of the argument, are you, Mr. Ellis?
No, I'm proposing
Dr. Ellis.
Mr. Edgeler deals with ground 4, the seizure of the computer.
Yes.
And the trial issue, if we need to address you on that. Otherwise, I'll deal with points 1, 2, 3, and 5.
So, and what's the division you've arrived at between yourselves as to the timing?
I was going to have today. My learned friends were going to have tomorrow, less an hour for reply.
Yes, I see. Well, then you may need to go slightly into tomorrow, but we've allowed the extra half hour. Right. Well, then you better introduce us to the roadmap which you propose to follow.
Yes, right.
Are you going to follow, in other words, basically your so described synopsis? And if you are, I think it would certainly be helpful if you would like to relate the part which you're addressing to the respondent's response so that we can see them in context. I don't know whether you're in a position to do that. It maybe we'll have to turn to the respondents, but I think that this is a case where there are a lot of points. They're dealt with on the two sides in different orders, and it might help us to have in mind the both sides' case when we're looking at any particular point.
And
well,
I hadn't got that.
Well, we will. What we can do is ourselves ask the Attorney General or Mr. Rafferty, depending which of them wants to answer, if we feel it necessary or appropriate to have in mind the response on a particular point. Right, rather than expect you to do that. But,
given that I note the implied dig at my synopsis, which is difficult to.
Well, I'm afraid to say it's slightly more extensive than we usually receive. But having said that, the importance of the issues is something we bear in mind.
It is difficult to call 155 pages a synopsis.
Yes.
I comprehend that. So.
Right, well, let's get down to the...
Right, well, there was... I'm aware that you've read both parties' submissions, and there is one matter that has arisen since I wrote my submissions, and I'm conscious of not handing you up vast amounts of extra material, so I've only at this stage got a single page, but there was a decision of the United Nations Human Rights Committee in April, which, from New Zealand, which touched on two issues that are of importance in this case, and I'm only going to refer to 2 paragraphs.
Well, if you're going to do that, let's see it, and we not infrequently are shown UNHRC committee reports, so it's...
Well, I can make it available electronically. The difficulty with making it available is we've only got the advanced unedited edition. I was trying to find the full edition to give to you rather than the advanced unedited one, but I can have
why don't you
agent email it registrar. Or I can...
Well, the AFA can, if need be, arrange copies. If
right, well, I've only
the
got...
email is in the form of the copy you've got there, is it?
Well, I've only given you the front page, which has the citation on it.
We need to see the whole thing.
Right.
Have we got it in front of us?
No, you haven't got it, because it only came out in April. I only really thought of it, to be quite honest, yesterday. So, making it relevant.
Get it to the registrar,
right, okay,
and ask them to copy it for us.
Okay. We will do. Right, and yes, that had to do with some aspects of independence and also judicial review. Now, you will have noticed that there's repeated reference in the submissions to the clanking medieval chains of the past, suggesting that the way that the Pitcairn judicial system has been set up is improper. And that finds its genesis, I suppose, in the way that the judges were appointed. And we know that in respect of ground one, that Finlay and the United Kingdom requires us, and I'm looking at my synopsis at page 15, paragraph 39.
Paragraph?
39's. That we need to consider the manner and appointment and duration of office, the existence from outside pressures, and whether the body presents an appearance of independence. And then we note that there are, for a population of 50, we have 13 judges in the Pitcairn jurisdiction, and we also note in this Rolls-Royce service we have today an Attorney General, a Deputy Public Prosecutor, so obviously there's a Public Prosecutor, and an Assistant Attorney General. So there's a massive amount of input put into the judicial system of Pitcairn, and the way the judges have been appointed is, with the exception of Justice Haynes at paragraph 43 and Justice Tompkins, this has all been done internally in New Zealand, and there's been no attempt to advertise beyond New Zealand. And what has happened is there's been an effective provision of judicial services from New Zealand rather than looking at the Constitution, which allows for appointments from any Commonwealth or Irish judge with 7 years' experience. But nobody in that category has been appointed. I say that at paragraph 46, there's a dilemma in that the Governor, who is the executive branch of Pitcairn, is also the legislative branch of Pitcairn, and that has a problem in terms of the separation of powers, in terms of the fact that there is no elected chamber in accordance with Barclay, your case in the Supreme Court involving Sark. We should have one universally, one chamber elected by universal suffrage. Plus we have the question of the UN Charter and the requirement that Pitcairn is held on sacred trust for the islanders, whereas the Governor doubles as the British High Commissioner, and obviously her...
Can you just wait a minute? I certainly missing some volumes. Right, sorry, carry on, yes.
Yes, sorry, the Governor doubles as the British High Commissioner to New Zealand, and her responsibility, my learned friends say, is just a mere assertion, is to the United Kingdom rather than to the Pitcairn Islanders, but I don't think so. And in paragraph 48 there's part 1, the relevant parts of Constitution section 1, partnership values between the United Kingdom are based on the following values: good faith, the rule of law, good government. And the rather strange propositions in subsections 2 and 3, in exercising their responsibilities, all organs of the government of Pitcairn have a duty to give effect to the partnership values. And the Constitution, if you're trying to look it up, is in 9, tab 34, right, 2878, the first tab in volume 9. And it's a little bit of a dichotomy, really. And my learned friends do say in their submissions, whilst the covenant applies in Pitcairn, it's not been incorporated into domestic law. And I think that's a slightly off-centre propositions, because you'll see at 2881 there the full list of partnership values, and 1H says compliance with the applicable international obligations of the United Kingdom and Pitcairn. And of course that relates to the covenant. Now, whilst the United Kingdom's international responsibility has permitted an extension to Pitcairn, the optional protocol allowing an individual complaint from Pitcairn is not in force, and neither is it in force in terms of the Strasbourg and the European Convention. And as you would no doubt recall, the Chagos Island case was thrown out by Strasbourg for lack of jurisdiction. So it stops here. We cannot go further than the Privy Council, which in a way is a form of discrimination, because every other British overseas territory doesn't have the same proposition, and it reinforces my proposition later that judicial review and the absence of a vigorous one doesn't allow for scrutiny of the government's position, because you can't take it to Strasbourg, you can't take it to Geneva. It's isolated to what you can do in the Pitcairn system. And I think one could argue that it is part of domestic law, because the Constitution must be supreme law for Pitcairn, and there's got to be compliance with international obligations of the United Kingdom and Pitcairn.
Well, what about subsection 3? Nothing in this section creates any legally enforceable rights or obligations. And as regards your complaint that you can't go to some international body, what about the traditional dualist approach which the common law takes to international law? In other words, international law is not part of domestic law, with certain exceptions for things like customary international law.
Yes, I understand the argument very well, but you have to read 3 and 2 together, 2 and 3 together. All organs of the government of Pitcairn, which include the Privy Council, have a duty to give effect to the partnership values, but it's not legally enforceable. But you could give a declaration, which is not legally enforceable. So, you know, you can't enforce a declaration. So,
I think you either have a right to seek a declaration or you don't, and if you're relying on a non-legally enforceable right or obligation as the basis of your declaration, I wouldn't have thought you could get a declaration. In other words, declarations are designed to reflect rights or obligations.
Well, I would agree in the normal sense, but with respect, I would suggest your interpretation is incorrect because of two, your duty is to give effect to the partnership
Yes.
values, and you can apply, but you can't enforce the declaration. There's nothing prohibiting you from applying for a declaration, but you may not be able to enforce it. But what it does show is the difficulty of the imbalance of power between the United Kingdom government in partnership with the Pitcairn government, and that one is left with this rather peculiar anomaly in 2 and 3. And I say that at my paragraph 49. And in just moving on a little bit, paragraph 53, I say the Constitution creates another conflict, and that is the payment of judges, in that judges must be paid from the public funds of Pitcairn.
So where have we gone to now?
Paragraph 53.
53.
Lord.
Page.
I think that isn't about the payment section.
Yes.
Comes later, doesn't it?
Yes, but I'm just saying
Oh, I see, yes,
another
it's-
conflict in the Constitution, just by way of introduction. And that really, I suppose, sets the scene there. And I have made mention in paragraphs 59 down to 62 about McConnell and the United Kingdom and the dual problems there. And then paragraph 63 relating to the this council's dual legislative and judicial role. I've just left it in there because
Yeah, we
my
saw
friend
that.
there don't change the numbers, so just ignore it. And then we have the appointments of judges exclusively from New Zealand, and you will see that where I'd currently got to really was that what should happen is judges who have a British education rather than British judges, because we're facing in this instance criminal charges in the Criminal Justice Act UK, and there is no consideration of appointments from people with a small culture, and as I say, being generous, 11 of the 53 Commonwealth members have less than 200,000 people, rather than the New Zealand, which has, well, it's now 5 million following the March census. And the proposition really comes, which is developed later, that what has been adopted here is a form of judicial colonialism, that Big Brother New Zealand is involved and has taken over in de facto the Pitcairn legal system. And then there is discussion of throughout that the various English laws that may or may not apply, because section 42 of the Constitution is the relevant section, which is at volume 9, 2898. The section 42, subject to subsection 2, the common law rules of equity and statutes of general application as in force in and for England for the time being shall be in force in Pitcairn. And we say, well, in that case, the various protections for Mr. Warren applying, if the Criminal Justice Act applied, should also apply, so that examples being the Constitutional Reform Act, how do you select judges, and also the various statutes, Promissory Oaths Act and the Senior Courts Act about the way judges are sworn in. And what seems to have happened, and I don't think I'm overstating it, if I am, I'm sure my learned friend will say so, what we have is acts of force in England which are favourable to the appellant don't apply, including the Bill of Rights Act 1688, PACE, Police and Criminal Evidence Act, and others, but we do apply the Criminal Justice Act when we say, no, the Summary Offences Act ordinance of Pitcairn covers the field, and that should have been where the charges were made. And that is, well, I don't know that I need to go through what Baroness Hale said there at 73 to 80. Skip that and move to 84, where I say no one from 52 Commonwealth countries has been appointed as a magistrate or judge. And I suppose I should just pause there 1 second to say that the island magistrate, who has very limited powers, but as you will have seen, issued the search warrant that started all this off, is an islander, and the 4 magistrates sit, well, I don't know that they do sit, well, whatever they do, which seems to be very little, is Auckland-based, they're all New Zealand-based, and the judges of the Supreme Court are all judges of the New Zealand District Court, which equates not quitely, but to your Crown Court, approximately. And the Chief Justice sits in that court, and he may also sit in the Court of Appeal, and he is the senior judge in the Pitcairn jurisdiction, and he has sat in both courts, as we may come to. But the Justice Haynes is in a different category to everybody else, in that he's not either an existing or retired judge of a New Zealand court. He's a QC practising in Auckland and chairman of the Human Rights Review Tribunal. And it becomes apparent that his method of remuneration is different to the rest. And I'm somewhat critical, as you will see from paragraph 84, on Justice Haynes' decision, in that he doesn't really understand the complexity of the argument, in that I say that the Chief Justice said he didn't want mavericks appointed to the New Zealand Bar, and then one has to work out what mavericks meant, and seemed to have a proprietorial approach. He wanted to make sure who was appointed to the bar, and didn't want any persons from the Commonwealth who might have other motives, because it may be in the previous Pitcairn case, the Operation Unique case, that was a matter of some importance, and I criticise the power of the Chief Justice to control admission to the bar based on what the Special Rapporteur on Independence of Judges and Lawyers says. I mean, it is inappropriate for the Chief Justice to be able to appoint judges and dismiss them from the bar. It should be the bar that has that proposition. And I say 87, Justice Haynes is selective in his judgment. He fails to mention the meeting of the Chief Justice with Baroness Scotland, and also the comment in 88 that one QC was refused admission to the Pitcairn Bar but appeared here by use of his British Overseas Practising Certificate, without any demur from your lordships. And then I go on to talk about the appointment of counsel or judges from smaller Pacific islands, which blends in later with the proposition that the prosecutor made recommendations for the appointment, that the public prosecutor made recommendations for the appointment of magistrates and the defence bar, and that I think is wrong. And it doesn't matter, like my friends say, oh, what does that matter, it's 15 years ago. If you set up a system which is wrong from the start and which doesn't have the appearance of independence or open justice, then the system is wrong. And particularly when you don't provide any checks and balances on the role of a prosecutor. And there's some discussion there with the charts that, at paragraph 90, that there's a commonly held view that lawyers from small island states are poorly educated in comparison to those educated in New Zealand, and I set out the various rankings which supports that proposition. If you're from Fiji, you're somewhere in the 2,000th to 10,000th ranked university in the world, and the New Zealand ones are in the top 300, and at 93, I say, conscious of all the biographies of your lordships that most, if not all of you, come from Oxford and Cambridge, and that's number 2 and 3 in the ranking, depending on which survey. Harvard's number 1, and the LSE is 7. So I say the obvious solution is that British educated lawyers are not likely to be mavericks. So why aren't we appointing them rather than just what the Chief Justice says I don't want mavericks.
Wouldn't that be even more obvious, open to your criticism of colonialism, judicial colonialism?
I see, yes, I hadn't thought of that. That's a possibility that I think McFarland, who's the author of the article on the small islands jurisdiction, and he says that the small states must strive to appoint their own judges, and I realise that's impractical in a situation where you've only got a population of 50 and you've probably got nobody with a law degree, but that doesn't stop the Pitcairners from having the ability, if they were given the opportunity, to nominate somebody from a small island. I mean, it can't simply be dismissed as saying, look, this is irrelevant because it's an impossibility. And I do acknowledge, Lord Mance, that yes, you could say it's having a bob each way and saying we shouldn't have judicial colonialism, but doing what I suggest would imply that happens. But given that the Constitution says you can appoint a judge with experience from one of 53 countries, then surely that must be considered. Well, I think it's more colonialist to only select from the New Zealand bench than it is from a wider selection. And I go as far as saying, adopting essentially what Professor Sue Farron says at paragraph 100, and others say, there's Tom, I've forgotten his name. Forgotten what his name was. Sure, I've got it in the footnotes. And Dawn Oliver and others say, look, discussing the previous Pitcairn case at the top of page 32 of my submission, illustrates a contemporary exercise of colonial government over a small island state. So I'm not manufacturing out of thin air a proposition that this is judicial colonialism. There is support for the proposition from public lawyers. And you do need to be in touch, as 102, paragraph 102 says, from the Bangalore principles, which you are aware Madam Justice Lever's described as the gold standard for judicial independence in the Gibraltar case, Gibraltar Chief Justice case. And the commentary there, the Bangalore principles, is suggesting that judicial fact-finding and evaluation and closeness to the community is important. And we have closeness is 5,500 kilometres away. And just because you visit the island once or twice doesn't give you the flavour of what's going on. And it's difficult to have a judicial system which is so remote. And at the top of the next page, 33, there's a extract from McFarland again, suggesting that you've got to be in touch with the community and familiar with historical, social and legal history. And this just is not possible by creating a system here. And there was a discussion, I understand, in the pre-Operation Unique trial days of whether there should be truth and reconciliation, some other form of judicial system. But anyway, McFarland there, 107, says that this can be seen as amounting to judicial colonialism.
Can I ask a question? Is there any threshold to your objection? Because the appointment of judges is notoriously a subject on which different countries have adopted very different lines. Some even elect them, some they're appointed by the government, some there are commissions. We've changed our system recently. Irrespective of that sort of change, it's been pointed out that the highest court in the United Kingdom is not necessarily as diverse as it some would think it should be. Our own president has made that point. Does any objection of that nature invalidate the whole system, or are we asked to look at something which is fundamental? Where is there a threshold, and if so, where is it?
Yes, I'm not sure that I know the answer to that, but I'll endeavour to provide one. What I'm saying is, and I do recognise there's been criticism of your own Supreme Court, which I had in Baroness Hale quote a little earlier in the submissions. But what I'm saying is that the trend is clearly to have community involvement in the appointment of judges, and there was material there saying I think 19% still, 19% of the Commonwealth countries still adopt the, let's call it the old system, but we have a threshold that says you may be a judge if you're a member from any one of 53 countries, and to confine the selection process to one of those 53 countries doesn't meet a reasonable threshold. I mean, whether you should have to advertise it everywhere may be too onerous, but certainly a stab at, for example, and I know this doesn't quite fit with my large size proposition, but the 11 countries which have less than 200,000 population, and perhaps England, Scotland, Northern Ireland, and Australia, perhaps Canada, Ireland, Republic of Ireland is included as an extra, although it's not a Commonwealth country, so there's got to be a minimum threshold, in my view, of a genuine attempt to select judges from the catchment pool that the Constitution provides. I hope that's...
Thank you. No, that's...
And perhaps lastly on that point at 108 there is no more room for executive and legislative colonialism in Pitcairn than there is for official colonialism. All British citizens, residents in the United Kingdom are entitled to trial by British judges. Pitcairn Islanders are British citizens, not New Zealand citizens. And they're likewise entitled to judges who are familiar with English criminal law, and they should have trial by provision, should not have trial by the provision of a New Zealand-based judicial system that is unjustified discrimination and colonialism. And in a way, I should stop here and just say we have, unlike England and Scotland, Northern Ireland, a very poor international human rights development. I mean, you've got Strasbourg. Our equivalent of Strasbourg is Geneva for the UN Committee, and over the years there have been 6 findings of breach of either the ICCPR, the Torture Convention, or the Working Group on Arbitrary Detention. And that's all.
So who's the we in that?
New Zealand.
Thank you.
Nobody from Pitcairn has done one, so we have 6. And one of the problems is there's no legal aid for the UN committee system. I'm the only practitioner who practices in that area regularly, and the only one who's ever won anything, which is disturbing, because well, in this case in particular, with the absence of funding for judicial review and the ability to take it to any of the international tribunals, it is worrying. And it's unfortunate that our human rights law in New Zealand, and I extend that to Pitcairn, is not as developed as it is because of Strasbourg. And the Chief Justice's power, I'm at the bottom of page 33, paragraph 109. Chief Justice's power to appoint.
Now this is a new point, which, yes. As we're told by the respondents, is that correct? And that it was never raised before?
No, it was
not
raised
correct.
Before.
Can you give us a reference to that?
Well, not off the top of my head, but we will be able to have a look at it lunch. No, I have been concerned about this previously, and there may be. I think there's a note for paragraph 120 and 121, Azerbaijan and Libya. That's new. But the point itself, it's more developed here than it was previously. And the simple point really is that you cannot allow the Chief Justice to appoint lawyers and dismiss them from the bar. That is the province of a bar association.
But, I mean, what is the significance of that in the present context? Mr. Warren has got you, and I think you're telling us that it's unlikely that he could have got anyone better experienced.
I wouldn't.
No, but I mean, the reality is, what is the nub of the point?
Systemic.
What is the significance in this case? It's
Point
a
is systemic.
systemic point.
That the entire appointment of members of the bar, and with the assistance of the public prosecutor who's recommending defence counsel, it is just wrong. You cannot have a judicial system that does not have the appearance of independence. And it doesn't matter about whether it's in this case or any case. It's far more important and beyond this case that the Chief Justice has this power concentrated into his hands, and it is criticised by the Special Rapporteur at 120 by the International and so on. And at 124, I refer to the Latimer House principles about advertising judicial posts. And I suppose that could be a threshold.
Is there any evidence that this power has been used to remove lawyers?
No, I don't, as far as I know.
Is there any evidence? What about appointment then?
Appointments, well, other than anecdotally that the QC, Mr. Illingworth, have had to apply 3 times, and the one that came here, Mr. Rogers, he was refused. And we had some minor difficulty. Mr. Edgler had to make 3 applications to.
So, but this hasn't been investigated in evidence.
No, I don't think it's been disputed, but it's not a matter of. Well, Mr. Edgler got appointed at the end of the day. It's not something that we focused on in an evidentiary basis. No. And I'm saying at 125 there that Justice Haynes took a narrow view of Commonwealth practice, in that we know that the appointments should be made by the Secretary of State, but we found, to our surprise, that the Governor had appointed initially President Robertson, and the method of appointment is the key factor in my submission in Finlay and the UK.
So you're back now on judicial appointments? Yes.
But the judicial and the legal appointments intermix into saying there is a systemic failure to have a judicial system that coalesces into the appearance of independence.
Yes, I think there should be a heading above paragraph 24 in your synopsis, shouldn't there? Really, because you switch, as Lord Lloyd Jones pointed out, in paragraph 24 you switch back to judicial appointments.
Yes,
for the rest
right.
of that section.
There's a subheading.
And at a later point you deal with the President.
Yes, that's correct. And as I think I said earlier, I did say 128, I said it the other way around, at 19% use the old approach, but the new approach is that we should have a judicial appointments commission and there should be community input and transparency, basically, and there isn't. That is not right. And at 130 there, I comment on the general comment of the Human Rights Committee. The requirement of independence refers in particular to the procedure and qualifications for the appointments of judges, and it must be clearly distinguishable to be compatible with the notion of an independent tribunal. And then there's reference to Slovakia, Zambia, Congo, and the Committee of Ministers for the Council of Europe. And then on to the unlawful Court of Appeal appointments at the heading above 136 and focus there chronologically, seems to be the easiest way to do it, with the appointment of the Chief Justice and noting that he considered the Court of Appeal and the Supreme Court, and he's the senior Pitcairn judge. And for some reason, he surrendered his precedent without reason to the President of the Court of Appeal. And equally...
Is it your submission that when a court sits with three people, one of them has more authority than others?
In a practical sense, somebody has got to preside, and it's traditionally one with most seniority.
Not what I asked.
No, in the sense of what happened here, it is my submission that the Chief Justice had more power and should have presided. If it wasn't the Chief Justice and the President of the Court of Appeal sitting, then somebody who wasn't the most senior judge could be able to sit, but it would require, in my submission, an explanation from the judges as to why that was happening.
Thank you.
Well, my Lord's question was a different one, I think. What is implicit in your submission is, I think, what we're interested in. Are you suggesting that someone sitting in my chair has greater influence on the substantive outcome? The person who presides may influence the course of the proceedings procedurally, but ultimately,
No.
when we go away in the common law tradition, each vote is equal to the other.
No, I'm not suggesting that. I'm suggesting that all judges are equal, and a Chief Justice or a President or a Deputy President has some additional administrative and chairing powers, but I'm not suggesting that they influence the vote in any way whatsoever. What I am saying is, if you are the Chief Justice and you surrender your precedence without explanation to a more junior judge in the hierarchy, it does not send a good signal to the public, and it requires explanation, an explanation that was not given. And that is wrong, because it was the Secretary of State who appoints the Chief Justice, it's not for the court to second guess his powers and say, oh, move aside, I was a judge of the Court of Appeal.
But what is the impact, either systemically or in relation to this case, of this point? Because this took place on a bail application, didn't it?
Yes.
A bail appeal in 2011.
Yes. It's further illustration of how the position of Chief Justice has been undermined by the behaviour of the Chief Justice, perhaps not in the extent that your findings in the Gibraltar case with the Chief Justice are, but there's the Chief Justice starts off by accepting a retrospective appointment for God only knows what reason, because he didn't do anything in the 6 months that was retrospective, but by setting that example that I'm going to, as a Chief Justice, accept an appointment retrospectively, it does not bode well for the very rule of law itself. Why would you do this? And then other judges, as we see, manage to get retrospective appointments by actions of this Privy Council in its legislative role. And the behaviour of the Chief Justice singularly, in terms of, okay, he didn't preside, might not seem all that important, and when you add it to the other factors, his behaviour as Chief Justice is inappropriate, and it undermines the appearance of independence in the Pitcairn system. So that's, and as I do say there, at 143, No individual prejudice is required for a systemic point, which this is. But we saw at 140, we're satisfied that the Chief Justice was appointed by the document of the 8th of June, has been in office from that time, from the time he swore his oath of office. Well, why do you take I still fail to understand, and I certainly can't explain it to you, why a Chief Justice would accept a retrospective appointment. It is an appalling, with respect, proposition for the Chief Judge of any jurisdiction to accept a pointless retrospective appointment. It sends a bad signal. Plus we know that the executive branch then suggests that it shouldn't be published. My learned friends say it was only for 3 weeks, which I think escaped me. If they say that, I accept it. But for however long it is, you can't keep quiet the appointment of the Chief Justice of your jurisdiction, particularly as he's the only judge of that court. And if he wanted to do a judicial review, well, you couldn't, because there isn't a judge capable of hearing it other than him. So I then move on to say that maybe 141 I should just say, because this case, as my learned friends say, had some significant complexities to get here, and one of those complexities was probably the yo-yoing between the Court of Appeal and the Supreme Court. And what in practice happened was Justice Lovell Smith, who is a district court judge and the executive court judge for Manukau, the largest criminal court in the country, was, with respect, unfamiliar with administrative and constitutional law. And the original appeal from her judgment consisted of 40 pages. I mean, absolutely everything was challenged, and that seems to have been countered by the appointment of Justice Haynes, who had a human rights background, and effectively everything was heard all over again, so there does get some confusion as to what was heard when. Anyway, going to paragraph 144, I say His Lordship, this is Justice Haynes, failed to consider the appearance of independence, a major error of law, and you will be familiar with the Scottish case of Miller and Dixon in your jurisdiction, and I've set out some extracts of what Lord Hope, Lord Clyde, and Lord Bingham say in there, and say, well, it's just wrong that you don't consider the appearance of independence as well as actual independence. And he got fixated on the question of whether Mr. Warren had suffered any prejudice. That is not the issue, as you know, from Miller and Dixon. 25% of the sheriffs in Scotland were found to be unlawfully in office. It's the systemic point that is important, not the individual point. It's not a question at 148 of what prejudice Mr. Warren suffers. It's a much bigger question. And I say keeping the appointment secret from the general public is not only deceptive, it doesn't comply with the rule of law. And we get a further example of that, which I'll come on to later, with the failure to advertise the Pitcairn Court of Appeal Order 2012, the retrospective appointments of the 3 Court of Appeal judges, which were not advertised in Pitcairn, and we only came across by accident, even though we're litigating the very point. The Foreign and Commonwealth Office try to remedy it in what I would call secret. anyway, where am I? And Justice Haynes was somewhat critical of the proposition made in 150 there that hole-in-the-corner decisions were made, which I say lacks context, which I was referring to Lord Steyn and his reference to after and hole-in-the-corner decisions, and you need notice of what's going on, and you certainly need notice of appointments. And it's also put, I think, at 152 there, it's really a natural justice point, elementary fairness, but the decision only takes effect upon communication. And then if I could move to page 45 with a right to truth or information, and my learned friends do take exception to the proposition that I'm now referring to the right to truth, which they say is new. I think that's a...
Well, I think they say that the word used was suppression. I'm not sure at the moment that the difference is going to matter very much. But if it's the same point, which you made...
I think it is the same point. I mean, if one looks at the Constitution, Section 13, the freedom of expression point, which you'll be well familiar with in Article 10, I think, isn't it, of the European logic. And I suppose I should have said, but you've no doubt picked it up, that the Constitution is an updated version of the European Convention of Human Rights. Yeah. Everybody has the right to freedom of expression. The right shall include freedom to hold opinions and to receive and impart information. And that's what I had argued in the courts below, that you had the right to receive this information. But as I read more about it for this hearing, it struck me that there was literature about the right to truth, but however we label it, it's the same point. So, and I've said that in paragraph 162. And the case of El Said, which I think was also told I didn't argue before, which I did, because I was very intrigued, because Sir David Baragwanath, who was a judge at the Court of Appeal of New Zealand, and he became a judge of the Court of Appeal of Pitcairn, although he never sat, and he had some more interesting international duties in the Hague, and he gave this decision, so it was obviously of some importance, and which is why I focused on it. And I suppose 167 and 168 might be worthy of some attention there, but the importance of the right, the access of justice I'm talking about, the long-term effect on Pitcairn. I mean, one can't help but wonder why the British government forks out 15 million a year to keep the place going, and it would no doubt be cheaper to give everybody a couple of million and resettle them in New Zealand or some of Chagos Island sort of approach, but presumably it's beyond my knowledge. It's got some 200-mile economic zone and the 3 islands, so there's quite a big economic zone in the ocean around it, which one might think the Falklands and oil. There's probably some logic to it. It's got some economic value in the future or some strategic value. I'm not suggesting it's going to have a American
I'm
Air
not
Base.
sure this is within our remit.
No, but I mean,
Well,
but
let's
it's
kick
just
it off.
there, isn't it? Why is this? But the Guardian there on 168 say, look, there's still undercurrents going on here, and anyway, I've set out in 169 what I say was the Chief Justice's involvement with the case and the President's involvement, and it is a little. I'm understating it if I say for a President of the Court of Appeal to be appointed 3 times before the colonial administration can get it right, and having the hearing of the Court of Appeal, which was on its 4th day, and the judges agreed that they hadn't sworn their oaths properly and had to adjourn, and were then sworn in by the Chief Justice, is somewhat strange, not to mention the retrospectivity of it, which we'll come to. So under the heading on page 49, we have the topic of Court of Appeal judges lawfully appointed, and as I say at 173 there, by accident we discovered this Privy Council ordering council, and it was news to everybody in our camp. And if we'd known about it, well, quite obviously, Mr. Warren would have objected to legislation retrospectively addressing such an issue. And I do say, as we have in Pitcairn, the Constitution in section 25(13), I think, that you've got to consider the jurisprudence of the European Court of Human Rights and higher courts of the United Kingdom. The Greek Stravos case, Greek, yes, in tab 9, page 2891, section 25(13) of the Constitution, in determining any question under this part, court shall take account of European Court of Human Rights and various other things, including E, declarations of the United Kingdom courts. So the Stavros case says you can't alter the playing field while the game is on. That's not a fair hearing. The government changes the rules, like retrospectively appointing judges. That is simply not a fair trial. You can't do that, and that's precisely what happened. So I say...
Well, we've had a case on this subject recently in the Privy Council on appeal from, I think, Trinidad and Tobago, called Ferguson. It doesn't appear to be referred to in your written cases on either side, but I think you might find it of interest.
Is that the one in February or this
I think
earlier
it was
this
earlier
year?
than that. I can give you a reference. Ferguson, the Attorney General of Trinidad and Tobago, and references JCPC 2015, and it's number 14. You'll find it on the website, and it deals with the distinction between ad hominem changes in the law and general changes in the law, and it identifies how you define the former ad hominem legislation and what the critical point is yes, it's a judgment of Lord Sumption's. I mean, basically, I think it depends upon the purpose. Is it specifically focused on changing? But in that case, changing the outcome of specific legislation, or is it the more general provision? But you need to read it, and there was in that case, I think it discusses the earlier, rather famous case of Lionargy, the Celanese case, where there was actually a sunset clause. The legislation was so specific that it was going to come to an end after the particular proceedings were disposed of. So it was clearly designed to influence those proceedings, and Lord Sumption suggests in paragraph 27 that that was a critical factor in that case. I mean, in Ferguson, there's no doubt that the legislation was designed to address a problem which had arisen in particular proceedings, but it was a general problem where the government formed the view that it had got the law wrong and it needed to be changed generally for all proceedings. So there wasn't a sunset provision or anything like that. And so you may have to face up to that sort of argument.
Yes, I will read it. I can see, don't want to be arrogant, but I can say that I can see the argument here is that it was clearly changed with this case in mind.
But that is not, I think, perhaps the test, as Ferguson suggests. That's the point you have to address, yes. whether it is critical that. Because there will always be some motive, and it may be a problem thrown up by particular proceedings.
Yes, well, all right.
May be the occasion for legislating, but the legislation may nevertheless be wholly general in its purpose and terms.
Anyway, read the case
yes.
and come back to it, because I think it's a case which you've been bounced with.
Right. Well, on the top of page 50 there, I'm quoting from the Foreign Office, the Select Committee, the Foreign Affairs Select Committee.
Tell me, this argument that this section doesn't deal with a different way of looking at what took place in relation to the order in council, and that might be ratification. I mean, there's no doubt the governor of Pitcairn purported to comply with the constitution of Pitcairn and appointing the 3 judges to the Court of Appeal, and it was then spotted that there didn't appear to be any evidence that he'd had the authority of the Secretary of State, but clearly later he got a lot of authority from the United Kingdom. Couldn't that be put in terms of ratification?
Yes,
by the order in council, if necessary.
Well, yes, I say, well, if we look at page 50 as to what's happening here, at the top of the page there, 1 to 4, we look at 3, doubts have arisen about whether the governor of Pitcairn has complied. It's therefore necessary to remove those doubts, so that's the reason. And then the Secretary of State purports to, I suppose ratify might be a good proposition, purports to ratify the appointment while the order is before the House of Commons, but it hasn't been passed yet, so he says, I agree with these appointments, whatever that means. And so he's done it wrong again, or the administration.
So where does he say that you quote it somewhere? I'm missing it at the moment.
The 181, the diplomatic telegram of 25th of July, in the light of...
Yes, quite.
Well, it's not...
Well, why isn't that capable of being reviewed as a ratification?
Well, because the order before the House doesn't become law until the 10th of August.
No, but if what was missing was the instructions from Her Majesty given through a Secretary of State, he could give instructions, couldn't he, ratifying without waiting for an order in council. An order in council is a sort of super ratification because he puts it up to the whole of the Privy Council in theory.
Yes.
He didn't. The Constitution doesn't say the Privy Council has to appoint. It says that Her Majesty, through a Secretary of State, has to instruct.
Yes, well, that's correct, but there's still a legislative power beyond what.
Of course.
But the proposition here is that whilst this secret process is going on before the House of Commons, the Secretary of State says...
Well, I mean, I don't want to take you up on every point, but I don't think it is a secret process before the House in the sense that it's hidden. It's what is put before the House by way of order in council is put openly before the House.
Yes, but not for those in Pitcairn.
No, well, that's a different point.
Which is the important aspect. Right. And your procedures, Hallsbury says you've got to advertise it in the locality, which it isn't. And we're 15,000 kilometres away, or whatever it is. So it's secret in terms of what's going on in Pitcairn. But nevertheless, what the Secretary of State is purporting to do is not ratifying. He says, I hereby instruct at 181 that I am in agreement with the appointment, the retrospective appointments effectively. Well, he might be. Well, so what? That's not exercising his power under the Constitution. He's just saying, I agree with it. Well, he should have said, I appoint A, B and C, which he does not do. And in any event, I need to read the Ferguson appointment and Lord Sumption's judgment, obviously. But my secondary argument on that point at the top of page 52 is it's a lack of due process, lack of natural justice. You don't know what's going on.
Yes.
I need to address you on that.
Can you just point us to the place where we find the authority for your proposition that an order of this kind is invalid unless brought to the attention of the Pitcairn Islanders?
Yes,
That is presumably, you mean by that, do you, in advance of promulgation?
Yes.
Right. Well, where's the authority for that, please? Just quickly, just give us a page.
Hallsbury's paragraph 203.
203 of your skeleton?
Yes.
Okay,
Yes.
thank you very much. That's good enough.
Wait a minute, paragraph 203, let's just...
203.
Yes.
Notice must be published stating the object. And that didn't happen.
Well, that's the purpose of presenting delegated legislation to the UK Parliament.
Yes.
Yeah.
And the same should happen in respect of Pitcairn. You can't have a process that is not due process. You must advise the inhabitants of Pitcairn that you're going to change their law. I mean, that is the problem, I suppose, with not having any democracy in the first place. And the democratic powers are exercised in London, not in Pitcairn. And this, illustrates the downside of it. And what is happening in my submission at paragraph 189 is what the UK Parliament is trying to do is correct a constitutional error that has occurred. There's an appointment by the wrong person, and I say this is bad faith, or alternatively, gross incompetence. You can't go around.
Can we just pause? The passage you cited from Hallsbury,
yes.
1406, is quite careful in making clear that invalidity only arises where the requirements of the empowering enactment are not complied with. There's no suggestion that there's some general common law principle.
Well, in my submission, so there is a common law principle. It's simply natural justice.
Not what it says, is it? Look at 1401. before a bill to confirm the provisional order is presented, certain preliminary proceedings are prescribed either by the Enabling Act or by the responsible government department. So you look to see what they are. Is that right?
Yes.
Okay. And 1406, no special procedural order valid until the requirements of the empowering enactment, etc. Now then, where is all I was asking? Where is the stipulation in the empowering enactment which justifies your submission that this order could not be valid unless first, in anticipation, brought to the attention of the islanders?
Right, well then, I would say to that, I cannot point to anything in the legislation.
So there isn't any?
No.
Okay.
Because we're referring to the British Settlements Act, and nobody would have thought of it in 1877, but what I do say is that the common law requires this, because natural justice requires that you know what's going on.
Right.
And Strasbourg would require this, because it's the manner and method of appointment of judges. And you've got to look at that. Strasbourg law says you do it. So regardless of whether it's in the legislation, there's two more possibilities, and it simply cannot be right that legislative powers are exercised without advising the local population, unless there's some form of national emergency that requires it, which obviously there wasn't.
Well, can I just ask you how far this point is open? The respondents say that it's an entirely new point. Is that right?
Sorry, what do they say?
The respondent says that the complaint about failure to give Mr. Warren an opportunity to be heard before the Pitcairn Court of Appeal Order 2012 was passed is an entirely new point. See their case at paragraphs 4.50 and 4.52. Is that right?
No.
Well, again, you'll have to give us chapter and verses to show that it was dealt with below.
Sure.
I mean, the ground rule is that if it wasn't dealt with below, you would require permission.
Yes, understood, my lord. But no, this was a matter of some discussion from the very first time it was discovered. We'll have to have a look at that. We seem to have dealt with breach of natural justice. Well, I suppose, no, perhaps not 205, Lord Hoffman there in the previous case from Pitcairn. Lordships would accept the fact that the law has not been published and could not reasonably be known to exist, maybe staying the prosecution. Well, we didn't know.
It's not said to be a ground for holding the law to be invalid.
Agreed.
So it simply affects the mens rea of the offence in a case where, unlike the offences charged in Christian and the Queen, there was no common law analogue to the relevant statutory offence.
Yes, that is correct, but in this case, of course, there is a Section 8 of the Summary Ordinance, Summary Offences Ordinance at Pitcairn, so there is in play a local equivalent, which there wasn't in the sexual abuse. And I think I'm saying at 208 that, by analogy with Golder and the United Kingdom, access to the court, there must be access to the legislature as well, and that there's a right of petition in the Bill of Rights 1688 to government ministers and so forth. So I'm trying to construct a legislative framework not in the British Settlement Act, which also covers it.
But again, I mean, what is the proposition that, how would there have been access to Parliament? The parliamentary procedure for scrutiny of orders in council is not something which, as far as I know, individuals have a right to participate in. They're put on block or possibly individually before, and they have to be accepted or rejected.
Yes, but the...
As a whole.
Yes, I agree, but the Pitcairn representative could lobby a British MP,
yes,
and ask for the order to be disallowed. So that's, you don't know it's there, you can't do that.
right.
And if you think of it, the select committee have actually said, hold on, give us an explanation of what you were doing with this. So they're onto it a bit. Well, they might have been onto it a lot more if there'd been some representation to it. And I think I'll discuss it with Professor Bradley how you did it, and do it retrospectively, but it just got too complicated. Complain retrospectively, but still, there we are. And then on page 58.
Do we know, you say that, as a matter of interest, the redacted memorandum which we have was issued in advance of the order being made or laid before Parliament. That's 179. We don't know the context in which it was produced, do we?
So we know that at 176 the memorandum was provided to the joint committee as to whether it was in Ferraris on the 22nd of October 2012. I mean, that is the entire memorandum. I haven't extracted.
It's a Foreign Office memorandum, so
Yes.
it was specifically related to
this issue.
case, and that's all we know. And we're not quite sure why it was, who it was for. Was it for Parliament?
It was for the Select Committee.
Thank you. Right.
And then there's some discussion at 196 of the Sabelli case, which I essentially say is clearly distinguishable because the legislative powers couldn't be exercised, and they were exercised as Joel Rios, if that's how you pronounce it, at 199 at the top of the page there, exercised only in cases of positive necessity and an extraordinary contingency, which this is not. There's nothing extraordinary or positively necessary. So the case that the Foreign and Commonwealth Office provide doesn't assist, and then my learned friends, of course, rely on it. But my comment, I suppose, is that at 200 and 202, the Governor of Texas in 1925 acted to ensure a hearing occurred by appointing an ad hoc bench of 3 female judges, as all the Supreme Court judges, males, were members of the Order of Rabbits, Masons, and they're all disqualified. So the Governor produced an ad hoc bench, which must have been difficult. Well, it was difficult in 1925 because the first person they appointed as Chief Justice, the First Lady, hadn't got the necessary 7 years qualifications. I had to appoint a second one, and by all accounts the decision was widely applauded, and I don't know what it did to the appointment of women judges, but that's beyond us. But in our case, in 201, the legislature, the executive and the judicial branch were still all capable of functioning, there's absolutely no reason why this process should be done. And Professor Bradley and Keith Ewing state at 202, a court might declare invalid the statutory instrument.
Well, the premise of this argument is that, according to Sabely, the plenary powers which exist include the power to legislate retrospectively, but only if there is no functioning local legislature, etc. But as I read Sabely, that observation, which you quoted in paragraph 197, only applies as regards the royal prerogative. In other words, the proposition is that the royal prerogative is superseded by a functioning local legislature and executive. But there is no such supersession in respect of the use of the British Settlements Act 1867. That is not subject to the same qualification. It's an out-and-out British statute which you apply according to its terms and which could be used to actually amend the Pitcairn Constitution. So you have to address that argument, which derives from a reading of Sabely, which you might take us to.
Right. Well, I think what one must be said there is that the Constitution, which requires the manner and method of appointment, was breached, and that is supreme Pitcairn law. And having created a Constitution of Pitcairn, one shouldn't, by stealth, go round effectively amending the Constitution by an imperial order which the public lawyers describe as clanking the medieval chains. That's what's happening here. And there should be a discussion, or there should have been a discussion before the Select Committee about the Constitution of Pitcairn. Why give them a Constitution and then the first time somebody slips up, you're busy amending it at Buckingham Palace with 4 Privy Councillors going along? It's just...
But, I mean, the point is that under the British Settlements Act 1867, it is open to the Crown to amend the Constitution, isn't it?
Yes, but this isn't done in that fashion, my lord. And not only that, it is my proposition that the British Settlements Act did not envisage retrospective appointments. Nobody would have thought about it in 1877. It is my submission that the Empowering Act doesn't go that far. So the whole thing's ultra vires anyway.
Well, I mean, that's contrary to Banku, isn't it? The British, in Banku, the majority held that the power to legislate for the good order and governance of British settled territories was unrestricted. It was as profound as Parliament's power to legislate in this country. So you're reading into it a restriction, aren't you?
Well, I'm saying that Bancorp doesn't represent good law in relation to Pitcairn, because if you look at the Constitution, it is no longer a prerogative power that can be exercised, because Section 36 of the Constitution.
But I think that seems to be accepted in the light of in Sabely, and again, I think probably in Banku, but the proposition is that the Crown can't use the prerogative once there is a functioning local constitution, executive, legislature, etc. But that doesn't deal with the legislative option, which Lord Denning in Sabely dealt with quite deliberately separately, and which he said was the answer to the case, because under the British Settlements Act 1867, there is unrestricted power to rearrange the constitutional shape of British settlements.
Yes, I understand that, but that must be read in the light of the legislative power granted to Pitcairn. So, Section 36 of the Constitution, at page 2896, volume 9, tab 34, the legislature, part 5. Subject to this Constitution, the Governor, acting after consultation with the Island Council, may make laws for the peace, order and good government of Pitcairn. So it's no longer the prerogative to be doing this. This has got to be done in accordance with Section 36. And
the answer is no longer the UK prerogative to legislate, even under the 1867 Act.
yes, not in terms of the legislature, because the United Kingdom Parliament has said this is supreme law for Pitcairn. So unless you're going to say we're repealing Section 36, which of course the UK Parliament could do, but it didn't, then it can't behave in the fashion that it did because of Section 36. And in any event, it would require now, which it didn't in Bancorp, whether this is good order, peace, order and good government of Pitcairn, and there was the exceptions in there, wasn't there, in the 3 judicial reviews you could do, irrationality and lack of proportionality. I can't remember the third one, whatever it was. But here we have the legislature comes along and says, here's how Pitcairn operates, and we've messed up under the Constitution. Pitcairn, well, it's for Pitcairn to sort that out, not for London to sort it out.
Good. Would that be a convenient moment? I
Yes.
understand it's been agreed there'll be a short break.
Yes, that would be very convenient, my Lord.
5 minutes. We'll do the best. Yeah. We're trying to reduce the heat in this room. I'm afraid something, apparently 2 coolers have broken.
I see, yes, I'm going bright red, I know, and trying to drink lots of water. But,
Right.
I should have said earlier, we have sent to the registrar the Miller and Carroll case, so it will get hopefully distributed. When it does, I can speak to it. I should have said I had a technological mishap last week when my laptop broke down altogether on Friday, and I had to buy a new one, and I'm not as au fait at finding things on my laptop as I was previously,
Well,
as I'm sure you all appreciate. Anyway, we were about to get to paragraph 196. We were there.
We've done that, haven't we?
Yeah, we were there. Sorry.
Except you, unless you want to actually refer us to Sabberley.
No, I don't think so. I think we've probably done enough on that particular aspect. If we move to 216, and I say I haven't yet read Ferguson, which I'll do at lunchtime because...
Yeah, that's where Ferguson comes.
And the Strand Greek refinery case.
What reference did I give you for Ferguson? Because
We've got it on the...
here I seem to have got a different reference, 2016 UKPC 2. Anyway, Ferguson against the Attorney General of Trinidad and Tobago. It's on the website.
Yeah, we've got
You've got
it on
yeah,
my
good.
laptop there. Well, I no disrespect, I suppose. I don't know if I've got to try and distinguish it with the Strasbourg case. I don't know, because I haven't read it yet, have I? But that would be somewhat intriguing and perhaps difficult. Anyway.
Well, I don't think it's inconsistent with the statement in the that you quote in paragraph 217. The principle can also be breached where a law is passed in order to influence the judicial determination of an ongoing legal dispute. As a general point, a provision, as it says lower down, aimed at the applicant company. There are circumstances, line RG is one, where that is the position. But the question is quite where the line draws and what the factors are.
Right, well, we'll return to that, so probably shouldn't deal with that section until so if we move to page 62 and the acting president.
Yes.
And I say that Sir Bruce Robertson's appointment as president was just one more example of the governor's administrative incompetence. He was not the president, he was only the acting president, and you could only appoint from the Court of Appeal bench as president, and that was required by the Secretary of State as set out in section 49(5). So I say the initial appointment was unlawful, but then...
What you can appoint, says those functions shall be performed by such one of the Justices of Appeal or such other person qualified for appointment as a Justice of Appeal. Wasn't he qualified for appointment as a Justice of Appeal?
Yes, he was, but he wasn't appointed.
Well, it doesn't have to be on this basis. You can...
Yeah, I see what you mean, yes. So by being appointed the president, you're saying he automatically is a member of the Court of Appeal. Yeah, I can see that logic. Yes.
So you don't pursue that point?
Correct.
Thank you.
Yeah. It was a short point there, wasn't it? 4 paragraphs. And then we had the failure to take the oaths of office. And we did, during the Court of Appeal hearing, attempt to get around the situation by giving a waiver so we could get on with it, because we've been 3 days through the Court of Appeal, and then in the, I suppose, the heat of the moment, we did give a waiver, and subsequently I thought better of it, because at the top of page 64 I say, well, you can't waive a public right, you can only waive a private right because of, I'm not sure how to pronounce that, Hakansson and Sweden. So the waiver must be made in an unequivocal manner and mustn't be counter to a public interest. And we hadn't considered the public interest. And the rather odd exchange as to what happened there, which I set out at paragraph 242, where I move from the transcript, on behalf, I move that the court incorporated as part of its record what we did on Monday to Wednesday, and the President asked for Mr. Rafferty, and he doesn't want to be heard, and then it will be entered into the court record, and then we see no reference to it in the judgment. It's somewhat odd, and I say, well, as it stands, it's not on the record. And it should have been. And then I think I said that the Section 7 of the Promissory Oath Act, that you're supposed to enter into your office by swearing your oath, and if you neglect to do so, you...
Well, now, let's just work out how these pieces of legislation come in. The Promissory Oaths Act, you say, comes in because you say the Constitutional Reform Act applies. Is that right? In Pitcairn?
Well, that would be a subsidiary proposition. I'm really saying it's
Comes in
an English law.
Yes.
Comes in under section 42, does it?
42.
Right.
An English law.
What about the Statutory Declarations Act, which you've referred to in paragraph 239?
239.
We don't seem to have got a copy of that, do we? It doesn't seem to be in the authorities, or am I wrong?
No, there was
I looked at it on the internet, and I couldn't see which provision says that the oaths sworn were unlawful. You say it makes it a strict offence, a liability offence, to administer an unlawful oath, which the governor, you say, was doing.
yes, and
I think you need to refer us to the section which says that.
well, I don't have an Archbold with me, but I was referring to...
Well, Archbold we don't have in the bundle of authorities either.
No, we don't. It was a very minor piece in Archbold which alerted me to it, and I regret to say that I haven't looked at it further there, that one, and I don't have my Archbold with me.
Well, we do have to chase this thing down.
Yes.
We can you do that over lunch? I don't think you may not get too much lunch.
No,
Well, we can look at it. We can look at it, Mr. Ellis.
Yes,
But which edition of Archbold was it? Because there's one every year, you know.
Yes, I've only bought one. I think.
Oh, well, if you don't know, it doesn't matter. We'll
I
find
think
it.
it was the 12th.
Now, why would you ask a
I think it's the 12th.
judicial assistant?
2012, I think.
Well, they go by the year. It's certainly not the 12th, but it's
Oh,
all
well,
right.
whatever. Well, sorry, I obviously not my mainstay.
Section 7 of the Promissory Oaths Act, Dr. Ellis, seems to relate to a refusal, or declining or neglecting to swear.
Yes.
Your complaint is not that they refused to swear the oath, but they did. They did.
Well, I do find that wording troublesome to advance my argument, because what I'm forced to say is by not taking your oath, you neglected to.
But you're complaining that they were in fact sworn in on 3 occasions.
Yes, but when we were sitting in the Court of Appeal, on the 4th day of the Court of Appeal hearing, I managed to persuade their lordships that they were unlawfully sitting because they hadn't taken their oaths, and then what followed was, that was Wednesday, so the Supreme Court was convened on Thursday with the Chief Justice, who came along and swore them in. So from that moment in time, my proposition is that was the only moment in time they were lawfully in office.
Or was there an occasion when an oath was required to be taken by them and was duly tendered to them, and they declined or neglected?
Yes, the first 3 days of the Court of Appeal hearing. They hadn't taken their oath of office.
I see.
And the Constitution has moved on a little, requiring you to... Not sure what it is. Somewhere in the 50s. No, I'll have to find that. The Constitution now requires you to take your oath of office, and you're not in office until you have.
That's in the Constitution, is it?
Yes, it is. I think it's in one of the 52, the general section, somewhere around. I'll locate it. If you can't, I'll make a note of it. get during their...
Try
What we're looking at what?
Try 52.5.
52, thank you.
Try 52.5. I'm not...
Yes, it doesn't say anything about it being in public, does it?
No, but for that we go to the Old English materials, which require you to, in 249, the Senior Courts Act, which isn't very old, is it? No, it refers back to the Promissory Oaths Act.
It's the Senior Courts Act rather than the Constitutional Reform Act, yes.
Yes, yeah, in the presence of the Lord Chief Justice and so on. So it certainly doesn't suggest you take it in private in the Governor's office in a foreign country.
Well, you may or may not be familiar with the procedures that are adopted in this country, but until recently, at least, all High Court judges, including me, were sworn in by the Lord Chancellor in his rooms, the House of Lords, and the current position in relation to circuit judges is that they're sworn in by the Lord Chief Justice in a room in the Royal Courts of Justice.
Well, I hesitate to say you've got it wrong.
Well,
why
that may be, Mr. Ellis, but you'll have to tell us why.
Yeah, well, because
that's why we're digging around in these Victorian statutes. The Senior Courts Act imports the Promissory Oaths Act, but it clearly wasn't thought that it applied before the Senior Courts Act was amended to its present form, which was no doubt after the, I imagine, after the Constitutional Reform Act. But whenever, it certainly wasn't the practice which prevailed when those older members of the judiciary were appointed.
well, maybe it should have been in accordance with
Well, I know you've got to make it good then.
Section 10 of the Senior Courts Act. In the case of a person other than the Lord Chief Justice, the required oaths are to be taken in the presence of the Lord Chief Justice or some other...
Yes, but your proposition is it has to be done in public, as I understand it.
Yes, my proposition is a little further than that, my
Right.
Lord. It should be done in public, and it should be done in Pitcairn, and not
right.
Auckland. And Pitcairn could, for these purposes, include an application to the Pitcairn Court to sit in Auckland, but it shouldn't be done. Oh, a video link, yes, could be a video link, but it's presumably logical to assert that it's more important for a population of 50 to know who's being appointed a judge than it is in the United Kingdom of some moment. But I think the concept of the manner of appointment, the Finlay proposition, and open justice require this to be done in public. I mean, why should it be done? Well, let's try it the other way round. If there isn't a statutory power authorising the swearing in public, how is it lawful? It's not for me to say to you...
That's a complete... The common law operates on the opposite. Unless something is prohibited, it is lawful. Can I just...
Not in terms of these judicial appointments.
Well, that's what we're trying to pin down. You're going to have to address us further on the Victorian statutes of applicability if you say they're applicable. But I'm just looking at what you say in 239, which about the Statutory Declarations Act and Archbold. The current edition is paragraph 28-201. That's the...
Yes.
I don't know what edition it is. It doesn't say. 2018. And I'm afraid it doesn't have anything to do with the present situation. It says it shall not be lawful for any justice of the peace or other person to administer or cause or allow to be administered or to receive or cause or allow to be received any oath, ... touching any matter or thing whereof such justice or other person hath not jurisdiction or cognizance by some statute in force at the time being, provided always that nothing herein contained shall be construed to extend to any oath, etc., before any justice in any matter or thing touching the preservation of the peace or the prosecution, trial or punishment of offences, or touching any proceedings before either of the Houses of Parliament or any committee thereof respectively, nor any oath, affidavit or affirmation which may be required by the laws of any foreign country to give validity to instruments in writing designed to be used in such foreign countries respectively. And then there's something about or oaths in courts of justice still to be taken. That's refers to judicial proceedings, oaths in the course of judicial proceedings. So it has nothing to do with this case. And
well, I don't know.
It's not very helpful, if I may say so,
Well,
to have a paragraph like paragraph 239, which suggests that this is a applicable strict liability offence.
Well, that's what I understood the edition that I was reading said. If it isn't, I apologise. Go to 250, please. Such oaths were to be taken in open court by virtue of Section 2 of the Promissory Oaths Act 1871 before the High Court. Quote, in open court before one or more judges of such court, or in open court at the General or Quarter Session. So that is public. Open court.
Do you want us, we ought to look at the Promissory Oaths Act, which is 3062.
3062. No, it's 3068. So
Okay.
50. Can you find it?
Is that right?
3068.
3068, is it? Yeah.
Yeah, that's where I got the proposition about
Right.
it should be in public.
So which section is it? Section 2, you say?
Yes. I'll start finding it.
Tab 50. .3068.
Thank you very much.
Yes, but even in England, that doesn't say that it has to be in open court in all circumstances, does it? It says, in England, before the Lord High Chancellor of Great Britain, or in the Court of Chancery, Queen's Bench, Common Pleas or Exchequer, in open court before one or more of the judges of such court, or in open court at the General or Quarter Sessions of the Peace, for the county borough or place in which the person taking the oath acts as justice. So it's notable that the oath before the Lord High Chancellor of Great Britain does not have to be in open court, which is how we all came to be sworn in.
It all begins, as far as I can see, before you get to the subparagraph which starts in England, be it enacted that each such officer shall take such oaths, the said oaths, before such persons as Her Majesty may from time to time to appoint, or
Yes,
the bit that you're then looking at.
Yeah. So the governor would be, in fact, if one applied this section, be within the initial bit.
Well, the tenor of the proposition is that you swear in open court, because presumably not very many of you, maybe different for the Supreme Court, are going to be sworn in before the Lord High Chancellor.
No, we all were. We all went down to Westminster and in his rooms,
Except for me.
except for Lord Sumption, who came straight here. Who states the system, but under the old system.
Well, I wasn't either, but...
All right, but not all of us.
Are you saying...
The older members.
Yes.
Are you saying you were sworn in as judges of the High Court?
Yes.
Or as the Supreme Court?
No, the High Court.
Well...
And indeed, the Court of Appeal was precisely the same procedure. So, I mean...
But the Lord...
You've got two problems with this section. Firstly is the word "be it enacted" before such persons as Her Majesty from time to time appoint, and then the word "or" in England before the Lord High Chancellor of Great Britain, full stop.
Well, the Lord High Chancellor was a judge as well as other
Yes.
aspects.
Yes.
And in my submission, the tenor of that section is that this is something done before a judicial officer. And what we have in Pitcairn is the swearing in is before an executive officer, not a judicial officer. And I still say that the tenor of this, regardless of how you got appointed, is that it's open. It should be open.
You say that we should read this section as requiring all judicial oaths to be taken in open court. Is that right?
Yes, my lord.
Really?
That's what
You really
I am.
do say that, do you?
That
All
is
right, okay, I've
absolutely
written it
what
down.
I'm
Thank you.
saying, yeah.
Right.
Now, the waiver, I think we probably, well, the waiver...
Well, at least there's no such difficulty in relation to membership of the Privy Council, which takes place in a slightly different
How does that take
way.
place?
Well, it isn't in it isn't in public, of course, so you might
It's not in public.
you go along and you attend Her Majesty in the
I
hearing
see.
of the Privy Council, a meeting of the Privy Council.
With members...
Members present of the Privy Council, but not, I think, outsiders.
Right, no, I wasn't aware of that. I should have bought your book.
Yeah.
So where was I? Oh, yes, there we are. At 263, yes, I found the passage where 52.5, which I'd forgotten earlier.
Right, we've looked at that, yes.
Yes, we've looked at that. And
And you say the consequences are that disqualification, effectively, invalid appointment.
yes, and that is also the situation in section 26 of the Oaths and Affirmations Act 1957 of New Zealand, and in some of the Australian jurisdictions too, which indicates that you're disqualified if you don't take your oath.
And so have I got it right? It's a two-stage argument, isn't it, Mr. Ellis? The various judges of whose oath-taking this can be said were invalidly sworn in. Those, of course, are not the people who made any of the decisions which are under challenge in the present proceedings. But you are, as I think, saying that it's an illustration of the fundamental invalidity of the Pitcairn Constitution, as a result of which the whole proceedings were invalid. Is that right?
I couldn't have put it better myself.
Well, you can try. But that's it, is it?
That is it.
Because
That is
none
it.
of these judges was in fact responsible for any of the decisions that we're being asked to re-examine.
Yes,
Were they?
that is totally correct.
Okay.
Because the essence of this case is not that what happened to Mr. Warren caused prejudice, but that there is a systemic breach
Yep.
of the Pitcairn Constitution and international human rights law, essentially.
Yep.
And then we had, down the bottom of page 68, the President was sworn in for a third time in Auckland, and that you need to swear in the President of the Court of Appeal 3 times does not advance the administration of justice or its appearance is extraordinary. I doubt that I've not been able to find a case where judges have been sworn in 3 times. So it's probably a unique situation, certainly in the Commonwealth. I wouldn't put past what happens in the United States.
Well, my recollection, I'm so sorry. My recollection, Mr. Ellis, is that when I was sworn in as a High Court judge, I was sworn in private by the Lord Chancellor, and then the next day I took the same oath, made this exactly the same oaths before the Lord Chief Justice.
Oh, that's interesting. Well, in our case, what we're having done is the Governor, with the exception of Justice Potter, is swearing in the judges in a foreign country. and not in not in public. There might be, in fact there must be a proposition that can be advanced. If you're going to swear in your judges in a foreign country, then you can do it in public, you should do it in public, because how are the inhabitants of your island going to know that this has happened? I don't know if I can go as far as to say it's secret, but it's certainly more than private if you're being sworn in a foreign jurisdiction. And there's no, at the time, certainly the Chief Justice was sworn in, there was no power for the Pitcairn Court to sit in New Zealand. So how was he sworn in a foreign country in private? That cannot be right. Anyway, I'm going to move. Sorry.
Can you just tell us why you say there's no power for the Pitcairn Court to sit in New Zealand?
When the Chief Justice was sworn in, because Section 15E of the Judicature Courts Ordinance didn't come into effect, or wasn't enacted until after the Chief Justice was sworn in.
Is there anything in the Constitution about where the court can sit?
Yes.
Where is it?
In the Court of Appeals section, I think it's section 53.
Yeah. Well, you're the expert on the Constitution,
Yeah, sure.
Mr. Ellis.
It's in the Judicature Courts Ordinance for...
No, I asked about the Constitution. Is there anything in the Constitution about it?
Yes, I understand what you asked for. And I'm trying to give you a full answer.
Right.
The Supreme Court and the Magistrate Court are not covered by the Constitution. The Court of Appeal is.
Thank you.
Certainly there's a general power there in section 51 that the President of the Court of Appeal may make rules for regulating the practice and procedure of the Court of Appeal with respect to appeals. And further one that says sit overseas. 56.3?
Section 53
53.
is maybe...
They sit in Pitcairn or elsewhere.
Yeah.
So it's for the President to make the rules as to where the court sits under 53, subsection 3, and under 51.1, the more general power. And the President, when we started this, was inadvertently misled by my friend, Mr. Rafferty, into thinking he had power to sit in
What about section 43(3) and 4? Sorry, and 5. Section 43, 4 and 5, really.
43.4
Of the Constitution.
Yeah.
43.4.
Yeah. Isn't that the same power as...
I think it's certainly a similar power, and we had quite a discussion about that in one of the lower courts about where the magistrate could lawfully sit, and that went on for...
No, but why doesn't this apply to...
That's
because it's a general provision rather than the specific provision about the President of the Court of Appeal making rules for where the Court of Appeal sits. So it's discussing courts other than the Court of Appeal, which is specifically covered in 50 subsection 3 and 51 subsection 1.
It's courts constituted by the governor.
Yeah.
Yes.
Not by the Constitution. And we had a long discussion about whether the Magistrates' Court was constituted by the governor or whether it lapsed when we had the Constitution, but we're not pursuing that point.
So what is the problem then about the Court of Appeal? I'm not quite sure what the point we're on is at the moment.
Yes, understandably. We had the problem that the power to sit otherwise than in Pitcairn did not arise until after the Chief Justice had been sworn into office.
Yeah,
so there was at the time no statutory power for him to be sworn in New Zealand. And
But is the taking of an oath, if this is the invalidity you're referring to, part of the exercise by the Court of Appeal of its jurisdiction and powers conferred on it by the Constitution?
I didn't quite.
I'm looking at your section 50 sub 3.
Ah, yes.
And I think you're assuming that the taking of the oath is a part of the exercise by the Court of Appeal of its jurisdiction or powers conferred on it by or under the Constitution. But I wonder if that assumption is correct. Because if it's not, it doesn't seem on the face of it to fall within section 50 sub 3.
Well, section 52(5), Lord, before entering into the functions of office, every holder shall make an oath or affirmation in accordance.
Yes.
So I'm saying what happened, we seem to have merged the Chief Justice and the Court of Appeal. So the Chief Justice simply couldn't have been sworn in New Zealand because there was no power to swear in. The judges of the Court of Appeal needed to be sworn in accordance with the section I've just read, which they hadn't been when they embarked upon their 3-day hearing in the Court of Appeal, and they were only sworn in lawfully on the 4th day. Which probably takes us to remuneration, because I'm going to have to go a little quicker. So remuneration, which is set out the tripartite statutory provisions as to what the Constitution requires are that you have a right to a fair trial, which you're totally familiar with Article 6, so we've got the same thing. We've got the more general proposition in section 44. I'm sorry, I'm on page 70 of my submission.
Right.
Independence of the judiciary. And then we've got the 2 subsections of remuneration, in that the remuneration is charged on the public funds of Pitcairn by the Constitution, and then we find that in the common law development of what we're talking about, financial independence, there's a mountain of Canadian litigation, and the Canadian Supreme Court seems to hold the view that you shouldn't involve yourself in your remuneration discussions because that's entering into the political arena, and suggest that you don't. And then we have the Bangalore Principles at the bottom of page 71 there. The manner of appointment, security of tenure, financial security and institutional independence, and 2 issues are in play in this appeal. The financial security and the institutional independence. Failure to have your power over your choice of courtrooms and when judges are available. And 285 there probably summarises it really. The proposition is that all Pitcairn judges have been subverting the Constitution by breaching the 3 sections I've mentioned because they are not paid by the Pitcairn public purse. The only judge who's paid by the Pitcairn public purse is Justice Haynes. They're all paid by foreign government, New Zealand. And I know that my friends say, well, you know, there's a good common law tradition that we New Zealand judges farm ourselves out to the South Pacific and and they don't get paid, but that doesn't make it right. And this is 2010, and the Constitution itself specifically says you must be paid from the Pitcairn public purse. It's that simple. They are not paid by the Pitcairn public purse, so it is unconstitutional, and that also applies to the trial judge. He was not paid by the Pitcairn public purse. He just received his New Zealand salary. And one can debate the moral rights and wrongs of giving assistance to, what are they called, undeveloped countries. But Pitcairn, I think, doesn't fall into that category. It's presumably richer than New Zealand, given that it has the backing of the United Kingdom. So why are the judges not paid in accordance with the Constitution? Very simply, they are not. And it's not only wrong in the sense that they are not paid in accordance with the Constitution, we then get the problem of judges are paid different amounts. So if one judge gets 300,000, the next one gets 200,000, the presiding judge might get a little bit more if they're holding the President's position or the Chief Justice's position. There's nothing offensive about that. But ordinary puny judges cannot be paid on a different salary basis to the others. And my friends say, well, it's the same as the New Zealand amount.
Why can't they be?
Because there isn't equality between judges, Your Honour.
Why does that?
Sorry, Your Lordship.
Why does that matter? Why should there be equality of pay?
There should be equality between each judge, because a member of the public coming along and saying Lord Sumption gets 200,000.
Yeah, but what difference does it make in practical terms? It happens in this jurisdiction, it happens in this court. If you've been Master of the Rolls, you have, as Master of the Rolls, salary which is in excess of the ordinary judicial salary of a justice of this court. If you're appointed to this court, you retain the Master of the Rolls' salary.
Well, every time a Privy Councillor from the Court of Appeal sits on this board, he receives a salary which is lower than that of the judges of the Supreme Court. They're all Privy Councillors, but they get paid different amounts.
I mean, the reality is that we don't think of these things as judges. They're completely irrelevant. There might be an occasional joke passed outside the judicial context, but I don't see how it bears on the performance of functions at all. I can see the negotiating point. I see that strongly, that it's undesirable to have judges negotiating about their salaries and saying, well, I won't serve unless I'm appointed, given more than X, but that's a different point.
Well, the point is really that the independence, the appearance of independence of the judiciary is corrupted if judges doing the same job are being paid something different.
Why? I mean, that's what puzzles me.
Because members of the public will see this judge is more important than that judge. I'll aim my remarks at that one. And it cannot be correct that judges of the same bench receive different amounts. If the Master of the Rolls has a built-in or the Lord Chief Justice has a built-in extra. I mean, I don't have any problem with that.
That's because you can't reduce judicial salary.
Yes.
But is there any reason to believe that they were paid different amounts in the present case?
Yes.
They were actually. You think? I mean, you have you got evidence that Justice Haynes was paid differently from those who were paid as New Zealand judges?
It's not in dispute that he received $287, $1,600 a day from the Pitcairn Perth, and the others received nothing because they're New Zealand judges.
No, but we don't. What's their New Zealand salary? What wasn't the Pitcairn salary by reference to the New Zealand salary?
Yes, at least that's what my learned friends say. It doesn't make any difference because if you calculate it, it's it comes to the same amount. But I, with respect, I disagree with my learned friends because salary is not the only method of determining remuneration. There are pensions, there are annual leave, there's sick leave. So trying to relate his $400,000 divided by 200 sitting days and you get 20, whatever you get, that's an inadequate method.
Well, if you're talking about
out.
Judicial pension, I mean,
Yes,
then if you look at almost any bench now in the senior courts or this court, you will find differences in the pension arrangements because the judicial pension was changed from time to time.
Well, in the jurisdiction that we're concerned with, there are no pension arrangements.
No, well, what we're looking at is the point of principle.
Yes.
I think we've got your point on the variations in amount. What's the problem about the fact that some salaries come from New Zealand, others from Pitcairn? And that's the constitutional point. You say that Pitcairn judges should be paid from the Pitcairn purse.
That's what the Constitution requires, so that's what the Governor and the Justices must do. It's not for them to ignore the Constitution, particularly in a case involving a constitutional challenge.
And what do you say is the consequence of that? Are you saying that a judge who is not paid out of the Pitcairn funds is disqualified from sitting, not properly appointed?
I'm saying, my Lord, that the consequence is that there cannot be a fair and impartial and independent tribunal.
So you accept that they are judges, but you say that it is inherently unfair for the proceedings to be conducted by somebody whose salary comes from Purse B rather than Purse A.
Well, I'm saying it's unconstitutional and it's also an appearance, it provides a lack of appearance of independence, which feeds into you can't get a fair trial.
Couldn't a judge say, look, I'm prepared to work for free?
Well, that's actually what they are doing.
Yes, well, why can't you say that? I mean, so you don't have to accept a salary. You say, I don't believe that, I believe I should save the Exchequer some money. I'm hugely rich. I'm going to work without payment.
No, the jurisprudence from Canada makes plain that you must have adequate remuneration to ensure that you have financial security. Otherwise, you don't fit the three ingredients of independence. Yeah. And you don't have it because you're not receiving it. So,
but all this is founded on Section 53, isn't it?
Yes.
That's where it all comes from, if you're right. And does 53(1) require there to be an agreement between the Governor and the judge for remuneration? Or does it simply say that if there is, the place that it must come from is the Pitcairn purse?
Well, my submission would be it does require that there is an agreement, and you can't have a remuneration nil. That is not remuneration. That does not fit the common law proposition that you have financial independence.
But if the purpose of the common law prohibition is to ensure that the judge has financial independence, and because he's a full-time judge of another court, being paid enough to ensure that he has financial independence, why is the common law provision interfered with? Because when he's working as a Pitcairn judge, he doesn't get extra?
Because the Pitcairn Constitution requires you're paid from the Pitcairn purse, not the New Zealand purse, and it is unconstitutional per se.
So the same would apply if it was an English High Court judge who was, for some reason or other, seconded to Pitcairn to try cases, perhaps because of some crisis. Would it?
Or Hong Kong.
Or Hong Kong, yes,
Yeah.
lots of other places.
Yeah. Well, my recollection of it was a Lord Chancellor appearing, I think, in the Cayman Island case, and leapfrogged this procedure and came straight to you in 1833 procedure, and the board said no, go away and do it properly. The Lord Chancellor or the Lord Chief Justice can appoint.
Yeah, I think it was Lord Faulkner, probably. Yeah. Lord Faulkner, was it, I think?
Yes, that's right.
Yes.
Yeah. And that would be my proposition,
Yeah.
that the Constitution says what it says, and it cannot be right that the rich, with respect, are favoured, so that you get a rich judge, and I'm going to say I don't want to be paid, rather than a poor judge.
Yeah.
I mean, that's not a position of principle. So everybody must be paid the same, and they must be paid from the public funds of Pitcairn.
Right.
And Lord Sumption doesn't agree, but never mind. I could move on to the administrative or institutional independence at page 77 of my submission, which is a simple point that the third limb of judicial independence is that you have institutional independence, and that means that you've got control of your courtrooms and the judges assigned to it. And what happens here is, of course, with the exception of Justice Haynes, you need to get the permission of the New Zealand authorities to release a judge to sit in Pitcairn, and then you've got to borrow a courtroom if you want to sit in a New Zealand court, which is what happened for virtually all of our hearings, with the odd exception when we sat in the Pitcairn Island office, which is situated in the British Consulate in Auckland. I can't remember how many days we sat in there, probably 3 or 4, but for the 60 days that my friends tell me we spent on this case, we sat in either the district court in Auckland or more belatedly in the High Court in Auckland. And there's no control of when the judges are available for sitting in a Pitcairn court, and there's no control of a courtroom. So I simply say that fails to provide administrative or institutional independence. And then if I could turn to the prosecutor's conflict at the top of page 78. I know my friends take exception to the proposition that it really doesn't matter. This is all so old, and what difference does it make? But if you haven't got a fair prosecutorial system, regardless when you've started, then it is wrong. And there was a human rights manual for prosecutors I saw there, footnote 111, and there was a whole series of articles following a conference where most of this material came from. And at paragraph 314, for example, the most important provisions of the UN guidelines of the role of prosecutors is you're separated from judicial function, and the guideline 13 at paragraph 322 carry out your functions impartially. And at 325, the American Bar Association criminal justice section standards are an authoritative source of guidance. Chief Justice Warren Burger said they're the single most comprehensive and monumental undertaking in the field of criminal justice ever attempted by the profession, and those standards said a prosecutor shall not recommend the services of a particular defence counsel or witnesses unless recommended by the accused person. And what we have here is the prosecutor is asked by the government legal advisor, renamed Attorney General for modern purposes, well, who would you recommend for appointment as magistrates and defence counsel? And I say that corrupts the integrity of the judicial system. And
is there evidence of this having happened, Mr.
yes,
of the nomination by a public prosecutor of defence counsel in a case with which he was concerned?
The construction of the bar, what there were recommendations made by the public prosecutor to the governor, and some were taken notice of and some weren't.
Yeah.
At the beginning of
Could you just give me the page reference where the evidence is of what happened?
674, isn't it?
Is that it?
I think it's the letter from 2000, 20th of March.
Yes.
Thank you very much indeed, it's very helpful.
Yes, so
That's magistrates.
sorry?
That's magistrates.
337. Yes, paragraph 337.
No, it is, I'm attaching a draft letter.
Suitable for engagement as defence counsel. Yes, thank you very much.
Various levels of importance.
Yeah.
And I've jumped a little bit with that question, but I'm saying, whilst the prosecutor recommended magistrates, my recollection is none of the people he recommended as magistrates were appointed. I might have got that wrong, but they certainly weren't appointed in this case. So we didn't have a magistrate for the preliminary hearing. But I say it's simply wrong. It doesn't uphold at 330, it doesn't uphold confidence in the principle of equality of arms or the administration of justice, or the appearance of independence as the prosecutor is recommending judicial officers. And a UN document, legal aid document, says, is there any indication that the prosecution service influenced the appointment of defence counsel? This is particularly true with emerging countries. The opportunity for prosecutors to influence the appointment of a defence bar and magistrates is plainly wrong and a conflict of interest. It's a breach of equality of arms, as the defence bar get no opportunity to comment on the appointment of the judicial officers or the defence bar. And why anybody as a prosecutor would be recommending who's going to be on the defence bar is somewhat, in my mind, startling. And at 334, Mr. Moore, the public prosecutor, now a High Court judge of New Zealand, says, you've asked me to turn my mind to potential nominees for the magistracy. And I say these are not actions of an independent prosecutor. And I make some comment at 347 that Mr. Moore...
Tell me this, I mean, it wasn't Mr. Moore in the position, he was, I think you said later, called Attorney General, but he was a distinguished practitioner. Did he not have something like an Attorney General's public responsibilities at that stage?
He was he was not the Attorney General, he was the public prosecutor.
Public prosecutor.
So like a Crown prosecutor here.
Like the Director of Public Prosecutions, yes. Was there anyone who fulfilled the role of Attorney General at that stage?
Yes.
There was?
Yes. The legal advisor who I think was called Paul Treadwell at the time.
That's the author of the letter you've been taking us
That's
to.
the author of the letter you're complaining about. But what I had in mind is that, am I not right, that in Australia and New Zealand, the Attorney General actually has a role in the appointment of judges?
Yes, the Attorney General, certainly in New Zealand, is responsible for recommending to the Governor-General the appointment of all justices with the exception of the Chief Justice.
And also
the
has
same
a
is
role.
true in Australia.
Prime Minister.
Yes. In Australia, the Attorney General effectively makes the appointment. Formally speaking, it's made by the Governor-General on his recommendation, but effectively it's his.
Yes.
This is because he has a public role, but he also has a role, doesn't he, a conventional role in charge of the prosecution service.
Yes, that's correct.
So he separates his public role, his public responsibilities, from his prosecutorial responsibilities.
Well, certainly in New Zealand, Mr. Moore was the Crown Solicitor for Auckland, so he's the largest public prosecution area in the country. So he was very experienced, and he was invited to be the public prosecutor for Pitcairn. But the correspondence between himself and Mr. Treadwell should not have happened. The Attorney General shouldn't have accepted a letter from him saying, here's my thoughts on who should be appointed magistrates or defence bar. It's just not on.
What so it's different from the New Zealand and Australian position at Pitcairn in that respect?
Well, in the sense that, no disrespect to my friend the Attorney General, I mean, we are talking about a much smaller jurisdiction, and I would say that Mr. Treadwell, who I think was an Auckland solicitor, Auckland barrister, had the experience gap between being an Auckland barrister to being effectively the Attorney General of a small British overseas territory, which at the time had an enormous inherited problem of sexual abuse of minors, was a big step. And obviously there was significant input from London, to manage that. But the public prosecutor gets appointed, but it was later in the piece that the public defender gets appointed. And I suppose you could logically say, I'm not even sure if that's right, but I'm just thinking of, could the public defender recommend members of the defence bar? Well, it's certainly more logical than the public prosecutor, and the public prosecutor should just never have been involved, and neither should the Attorney General. I mean, it is wrong. And given that Britain set up this enormous Rolls-Royce judicial system, you've got to live by the rule of law, and the rule of law cannot mean the prosecutor runs around nominating members of the defence bar. The independence of that is obvious to any well-informed independent observer, that it is not independent. And I address the prosecution guidelines, they're the UN guidelines, on page 86, that there should be guidelines, rules or regulations which enhance fairness and consistency, and at 358 there, looking at the special rapporteur in assessing the independence and impartiality, it's important to examine both the structural independence and their operational independence.
Right.
And there were no guidelines, and there still are no guidelines. So allowing the public prosecutor to do what he likes is not consistent with international best practice.
Well, you have to go further than that, don't you? You have to say it's unlawful. And it's unlawful because?
It is unlawful because there's no control on the discretion of the public prosecutor, particularly in a system.
Yeah, but where's the hard legal requirement? Is it the right to a fair trial, or is it something else?
It's the right to a fair trial.
It's the right to a fair trial.
And the lack of judicial review, which we haven't got to yet, makes it even more crucial, because I am convinced that the absence of an effective judicial review system means that the government is immune from scrutiny, and that's what I wanted to come back to.
I don't think we're...
How does that affect this case?
Conviction. Sorry, I didn't catch that.
Sorry, no, yes, Lord Sampson, yeah.
How does that affect this case? Suppose you're right and there's no effective system of judicial review. Why does that undermine the validity of your client's conviction?
Well, because what my friends say is that instead of bringing the appeals in the fashion that they should have been brought by way of judicial review. And I say it's impossible to bring it by way of judicial review, because there's never been a judicial review apart from a belated one in this system, because there was no system of judicial review set up in Pitcairn, and there's no legal aid, and as nobody in Pitcairn can afford a lawyer, you're effectively saying the government is immune from having its decision-making reviewed.
So the absence of judicial review comes in, does it, in response or riposte
Yes.
to the attorney's argument that there was an alternative remedy,
Yes.
and your various constitutional points should therefore not be dealt with, should have been dealt with under Section 25, and do not have to be dealt with within the criminal procedure.
Yes. So
Okay.
we should have gone to the Supreme Court, not done any of this, and brought it all by judicial review. And the Miller case, which you may have got by now, I don't know if you have, as the registrar handed it.
Yes.
You have got
Yeah,
it?
well, we've got it on, I've got it on the internet. The UNHCR one.
I beg your pardon?
Is it the UNHCR one you're referring to?
Yes.
Yes. Yeah.
Find it for I wanted to refer to paragraph 8.15 and 8.16 of the decision.
Yes.
Only. It's a preventive detention decision which had as part of the argument that there was the lack of independence of the parole board, and that found its genesis in, if you're looking at 8.15, in the case about 7 or 8 lines down, case of Remika and New Zealand, as to whether the parole board was a court or not. And interesting aside, but probably nothing more than that, is Remika, I think, is the only case that's been before the Privy Council where leave was refused, and then the Human Rights Committee found in favour of the author.
That's a case about whether there was adequate access to court and whether the parole board was sufficiently judicial, which it was held not to be. But here, just try and get the shape of the argument in my head. The argument is that the whole judicial system is vulnerable to criticism, and that you can't raise that point in the course of the criminal proceedings. Is that the argument? And therefore there must be a judicial review process to counter it? Because the Attorney General's argument, as I see it, is if you're hauled in front of a court which really doesn't have jurisdiction, you can take that point before the court. If it's an abuse of process, likewise, you can take that point before the court. And if need be, you can go up to the Privy Council, which undoubtedly does exist as a court and can hear you within the legal system without any need to worry about separate judicial review possibilities. What's the answer to that? Have I put it wrongly?
I don't think so. The answer is partly what I'm trying to say here in this paragraph. You go to the last sentence,
Yes.
please, of 8.15.
Yeah.
Accordingly, the committee considers that the state party failed to show that judicial review over the lawfulness of detention was available to the authors to challenge their continued detention. So they're saying judicial review, it's a little bit like Weeks in the UK, if you can remember that far back, and judicial review is not a sufficiently adequate remedy. And therefore, they say in 8.16, therefore we're not going to consider your allegation of lack of independence and impartiality of the board because the parole board isn't sufficiently empowered to look at matters, and as you can only judicially review it, you don't have a remedy that's of any use. And I say here, well, even if we had gone down the judicial review remedy, the Human Rights Committee are saying that's an inadequate remedy, and you really need, in simple terms, you really need an appeal right rather than a judicial review.
Yeah, but you've got an appeal right, and what worries me is the respondents say, the Attorney General says that he's not suggesting you should have pursued judicial review. His point is that you've raised various purportedly constitutional points, and they could have been raised in the criminal proceedings and appealed up to us, and that's the remedy. As I understand it, that's how he puts it. Is that?
Well, I think that's, yes, I think that's his position. I say that we were encouraged to file a judicial review, and we did, and even before Justice Lovell Smith, in the first major embarkation on this case, I simply said, well, treat it as a judicial review.
Yeah, but I mean, even if I'm wrong in suggesting the way I described the Attorney General's argument, his argument is certainly that there's no need for judicial review, one way or another. You can either challenge this as part of the ordinary abuse of process jurisdiction within the criminal proceedings, or else you can raise the constitutional points in the criminal proceedings. But this judicial review argument is a hare, he says, nothing to do with this case, because he wasn't suggesting that you should be taking separate judicial review proceedings. That seems to have arisen from some discussion where he said to you, well, if you're saying that if you're referring to judicial review being inadequate, it's open to you to bring judicial review proceedings. I don't think he was actually saying you should do that.
Well, that was certainly the argument in the courts below, that we shouldn't be hearing a constitutional challenge. We should have embarked upon a judicial review. So if we've reached that point now, we've changed track.
I see. Well, we may have to hear from the Attorney General on that. But anyway, we probably covered it sufficiently.
Yeah, yes, I think so. If I could do the last point on this independence issue, I think.
Of the island magistrate, yes.
Yes, that one there. And then that's fairly simple. The island magistrate, we're on page 88.
I think we've got the picture. I mean, you say it's a rather unusual position where the deputy mayor is also the island magistrate and can issue a search warrant in respect to the mayor and has some sort of potential personal interest in becoming mayor because you say he'd also, well, he'd exercise the authority and receive the pay.
Apparently, my learned junior tells me he is now the mayor. Yes, No, he's not the mayor.
How does it work? Does he step in if does the deputy mayor step in if the existing mayor is for some reason or other unable to act?
Yes.
That's my understanding.
Paragraph 364.
Well, that's, yes.
Until the next mayoral election.
Yeah.
But
Yes.
does he get paid then as if he were the mayor? I think you assume he does.
I would assume so.
Right. Anyway, you say this is a question of evaluation. You say that this is across the line.
Am I right in understanding that the next election was 6 months away?
Yes.
No. But
And there was power for any of the 4 New Zealand resident magistrates to issue a warrant. There's no need for it to be the local island magistrate, and this wasn't.
But what's the consequence? I mean, supposing we disagreed with the courts below on this, just suppose, we'd be left with a situation where the search warrant shouldn't have been issued, but does that mean that the whole trial, which wasn't based on the search warrant, it was based on the material discovered on the search, it was based on objective evidence, fails?
Fruit of the poison tree, yes, the search
But we
warrant
don't have a
obtained.
fruit of the poison tree doctrine in an absolute terms. We have the Sang principle, and if you apply pace, we have section 78. It depends on unfairness.
Well, yes, but then when we raised pace, we were told it didn't apply.
No, well, either at common law or under pace, there is no fruit of the poison tree doctrine.
Well, it's an expression that illustrates what I'm talking about.
Well, it's rather important that you don't misuse it, Mr. Rose, if I may say so. I know that it's frequently bandied about. The law of England does not recognise any notion of automatic inadmissibility of evidence as a result of the irregularity of the way in which it came into the hands of either party.
Yes, and that...
DPP and Sang, Khan, a list of cases so long that we'd be here until tea time.
That's also the law of New Zealand. It's a balance.
Right. Well, then, could we please not have any further conversation about the fruit of the poison tree, which is an American doctrine which works exactly the opposite way?
Well, what I'm saying is, if on a balancing exercise, the items seized under the search warrant were excluded,
Yes.
then there is no evidence and there would have been no trial.
Well, that's right.
Exclusion doesn't follow.
Oh, I understand it doesn't. I said if it happened. And
Yeah, well, what's your submission? I mean, are you submitting that they would have been in this case? Because it makes a bit of difference.
yes, I am submitting that, but I'm...
You have to say, don't you, that they would have to be excluded.
Yes.
And you say that because?
Well, because the island magistrate who issued the warrant was not an independent...
Well, that's going back full circle.
Yes, it
you
is,
see.
but my learned friend is going to deal with the issue in
All right.
his bit, so I'm trespassing upon his territory. What I'm saying is he's not independent, and neither is he impartial, and at 368 there I'm referring to what Lady Lovell-Smith said in terms of apparent bias is inevitable, but the legislature had provided for, well, if there's some bias, you can appoint a temporary island magistrate. So it's, with respect, an absurd proposition that because your island is small, there's going to be apparent bias, and therefore we've got to put up with it when there's at least 4 alternative magistrates, not to mention the justices available. So it's not correct. And her ladyship also didn't consider the appearance of independence or the appearance of bias in her judgment at 378. I see it's 1 o'clock, so I'll just take 30 seconds more, and it might be appropriate to adjourn. So at 380 there, I'm saying there's her ladyship's effectively abolishing the rule against bias because the island is small and this is wrong and unprincipled. And equally at 385, I say that it's an automatic disqualification on Pinochet principles because you've got an interest in the financial outcome.
Well, you're not bound to be appointed as, you're not bound to be given the mayor's salary, are you? You just assume that...
I've just assumed that.
Just assume that, yeah.
But the salary, well, it's more than salary, isn't it, I suppose, because you've got the number one position on the island. I mean,
And it's only if, I mean, is he bound to be removed as mayor
No.
Simply because of a search warrant?
No,
No.
and there was suggestions from the authority that he stood down, which he resisted and refused to do.
I see. So he was removed, was he?
No,
Or-
no, he wasn't.
He wasn't?
He expired with the effluxion of time.
Oh, he served for 6 months.
Oh, was he re-elected? Apparently he was re-elected.
Re-elected.
Well, yes, but then one of the Operation Unique major offenders was the assessor in the trial. There's all sorts of weird and wonderful things that happen. But if I could just finish with one comment there before lunch at 386, which we touched upon. Section 25 cannot be used as there's no breach of Section 8 or any Pitcairn constitutional right. So we got into that dilemma, and I say no.
Yeah.
We must have, this is a fair trial right, and by analogy at 388 there, the New Zealand Pitcairn Trials Act says a trial includes the issue of a search warrant, and search warrants are included in Section 8 or in Constitution 21 on the natural justice right. And then if it was invalid, then Section 78 of the case should apply, but the Pitcairn Court said it didn't apply. So you've got the English charges applying, but you don't have the English defences applying.
Yeah, we've got that point.
All right, and that would be a good place to stop.
Well, we'll adjourn till 2 o'clock. Thank you very much indeed.